Thank you, Mr. Chairman, and thank you to all of our witnesses for being here today. We appreciate your testimony and your attendance. I'd like to start, Commissioner Cooksey, with you and a little bit of background on circumstances in which individuals have a right to sue the agency for inaction. In particular, I'm interested in the circumstance where the agency is sued in court, but commissioners decline to defend the lawsuit. Is that something that you've seen occurring?
Thank you for the question, Representative. Yes, it is. So under our statute, as it's written, when a private party files a complaint with the commission, they have the right to sue the commission for undue delay if the commission doesn't act on their complaint in a timely manner, if we don't have a good reason for that. And if they win that lawsuit, they then gain a private right of action to sue the party they complained against directly for violating campaign finance law. To defend the agency in an undue delay suit requires a commission vote. It requires 4 commissioners to defend the agency, and it's something that was routinely done up until about 5 or 6 years ago, where there was a period of time in which a number of commissioners were engaging in a strategy of not only refusing to close case files that the commission had voted on. In other words, the commission had considered the merits of a case, had voted on it, had decided not to go forward, but then certain commissioners would refuse to end that case, to disclose it to the parties. And then when we were sued for undue delay, those same commissioners would block the agency from defending itself in court. So the government was basically a no-show in federal court.
What happens when an agency fails to appear and is essentially a no-show after being sued in federal court?
Well, a number of things can happen. There can be show cause orders, there can be sanctions, but most typically what's happened is that the court simply issues a default judgment against the agency, and the party that sued us goes on and sues with their private right of action they've gained.
And how does the entry of a default judgment affect the FEC, and what happens next?
Well, it affects us in a number of ways. One, certainly we're, at the most basic level, we're not allowed to share what the commission has done, to share how we have acted on a case and to defend ourselves. And ultimately it leads to a sort of paralysis at the commission and our ability to get our work done.
And now, as you might be aware, the American Confidence in Elections Act, which is a piece of legislation that passed out of our committee just a few months ago, we require a unanimous vote of the commissioners in order to decline to defend the agency in court. Do you believe this would be a positive change?
Absolutely. I would strongly encourage Congress to change the statute that governs how the agency defends itself. I think it's, frankly, a scandal for the federal government to not show up in federal court to defend itself.
All right, thank you. I'd also like to touch on the something that you mentioned in your opening statement that I think it is important to highlight, and that is, I believe you mentioned in the large majority of your cases are resolved in a bipartisan way. Could you tell us a little bit more about that?
Sure. So, I mean, I think like many issues, people tend to focus on the division and to exaggerate it. But if you look at the overall enforcement docket at the commission, if you look at the hundreds of cases we've closed over the last 3 years, the vast majority of those we reach some kind of bipartisan agreement. It may not be unanimous. It may not be, the exact same recommendations that the career staff have made. But 9 times out of 10, if you consider our entire enforcement docket, there are 4 commissioners, meaning at least 1 Republican and at least 1 Democrat, that can agree on some outcome to an enforcement matter.
And then I'd like to turn now to one thing that you also highlighted and that we commend you for is your significant work to reduce the number of cases, the backlog of cases that are pending. Nonetheless, you all are faced with a very large volume of cases and a very large workload. Would you speak with us a little bit about how discretion about which cases to pursue and which cases to close, how that affects your work and how that is important to your management of the overall caseload that you have?
Absolutely. So prosecutorial discretion is an important part of our agency and how we manage our enforcement docket. We, simply put, don't have the resources to pursue every single complaint for a number of reasons. And there are situations in which, in our judgment, it's throwing good money after bad, and to put it one way, to pursue certain kinds of enforcement cases that we don't think are worth our while relative to other priorities. And so the exercise of prosecutorial discretion is an important feature of how we manage our enforcement docket in order to essentially maximize the effect we have in enforcing the law.
All right, thank you. Out of time, Mr. Chairman, I yield back.
Thank you very much.